A group of anti-mandatory vaccination will need to wait for February the 3rd, 2022 to have their argument heard by the court of law. Following a telephonic postponement of the case by the Chief Justice Sakwane last week, the case was heard by Justice Monaphathi today, and the advocate representing the state, Advocate Monaphathi, argued that his office was not served with relevant papers, thus was unable to argue, adding that the applicant showed hostility.
And that is why I was actually recording yesterday that indeed we are hamstrung by not being served by another colleague. We should have served our office so that we could come before we could move the application. Well, due to the deliberations yesterday, it seems then he was minded now to serve us. And he served us late at around 4:15. Yesterday, before we knocked off. His attitude yesterday was so hostile that I could not entertain, because I tried to call him about him saving us, and then he was saying, no, I don't want to serve him, and I'm not intending to do so. So actually I was not interested at all today to engage in another interrogation with him regarding the service and as well as, but if the call permits, then we can sit down and see and talk, but actually we are opposing it.
Sehapi stated that Chief Justice Sakwane had advised High Court Assistant Registrar Advocate Stafford Shariti to defer the matter to next month when the court resumes its duties, while the lawyers to represent the applicants in the matter were not addressed or made aware of the decision.
It was postponed without us even being heard. It was postponed by, or let me say, through the person of the Assistant Registry. So, who postponed it? The postponement was communicated through Mr. Shariti after Mr. Shariti has read the face of the prayers to the Chief Justice. So our take, my Lord, is that the matter was in effect postponed by Mr. Shariti himself. And as you can be aware, my Lord, there is a decision that the registrar or assistant registrar have no power to postpone the matter, because their power to postpone the matter is strictly a judicial power. It's strictly that is conferred to the judge, and the judge cannot delegate those powers.
It is in this where Advocate Fusisi Happy, on behalf of the anti-mandatory vaccination, is suing the state, which was represented by Monaphathi, for the enforced vaccination and denying people the right of access to shops, public and private essential services such as healthcare, to the threat or violation of their fundamental rights to life. The matter was pushed to February the 3rd, with Justice Monaphathi saying it is a serious weakness if one is not granted an opportunity to respond, because those are procedural requirements for every case.
It is a serious weakness if one is not given such an opportunity.
Yes, sir.
Primarily because, as you have said, these are procedural requirements. They are not a matter of substance.
Yes.
But they are intended to end up where? To end up where the substance will be interrogated.
That is
the
it.
substance itself.
Yes, sir.
And where anything is placed, is put in the place of the ability to respond. That thing the court will avoid. And the court will avoid that in the discussion. And that discussion will always be guided by fairness and avoiding prejudice. That's why the court will always strive towards giving an opportunity.